The following is a redacted version of our criminal justice system within the federal courts. This summary is designed merely to offer insight into the operations of our federal courts and U.S. Probation and Pretrial Services system. For more detailed information, please visit the U.S. Courts website at www.uscourts.gov. The criminal justice system seeks to deliver justice and provide rehabilitative programming which aids in the successful transformation and reintegration of those convicted of crimes within their respective jurisdiction. The criminal justice system is a compilation of government agencies and institutions which consist of the following: law enforcement, courts, and corrections. There are 5 stages of the criminal justice system: entry into the system, prosecution and pretrial, adjudication, sentencing, and appeals. This video presentation provides a brief summary concerning U.S. Pretrial Services. Entry into the system. The first point of contact an individual has when entering the criminal justice system is usually with law enforcement officials responsible for investigating the commission of a crime. In the example provided, the home of a dwelling is burglarized. The homeowner is awakened and contacts law enforcement. Police arrives and execute an arrest. The individual is taken to the local county jail or detention facility for processing by local jail officials and/or the U.S. Marshals Service. Upon arrival, the individual, now referred to as inmate in most correctional settings, is booked into the county jail or detention facility. This involves photographing, fingerprinting, assignment of jail number, and cell location. The inmate remains in custody, awaiting his or her initial appearance before a federal judge. Prosecution and pretrial. The courts serve as the venue where disputes are settled and justice is administered. With respect to criminal justice, the court's working group typically involves the judge or magistrate, prosecutor, and defense attorney. However, there are others who play a role in the fair administration of justice. After having been processed by the U.S. Marshals Service, booked into the county jail or detention facility, or self-surrendered, inmates typically appear before U.S. magistrate judges immediately without unnecessary delay. It is here where inmates, now referred to as defendants in the court setting, learn of the charges filed against them as supported by the prosecutor. To assist with responding to the charges, defendants who are unable to afford counsel have a right to a court-appointed attorney. U.S. magistrate judges review the complaint or other charging document for probable cause and a determination concerning custody status. In preparation for such, the U.S. Probation and Pretrial Services Office responds by interviewing defendants. The Pretrial Services Officer gathers critical background information as part of their interview to help the court determine whether the defendant is a flight risk or danger to the community. The Pretrial Services Officer reviews criminal history data, obtains social history information from the defendant, such as family, physical and mental health, educational, and financial background data. And the Pretrial Services Officer speaks with third parties to confirm the information provided by the defendant. Upon completion of the interview, the Pretrial Services Officer prepares a written report and submits to the court with a recommendation for either release or detention. The written report, commonly referred to as the Pretrial Services Bail Report, is forwarded to a federal judge with a copy furnished to the prosecutor and defense attorney. The federal judge reviews the Pretrial Services Bail Report alongside the parties. Questions are asked and testimony may be requested. However, the federal judge relies upon this information, facts of the case, and any other information necessary to assist in his or her decision to release or detain the defendant. The defendant may be granted bail, pretrial supervision, or a combination of both. If released and granted pretrial supervision, the defendant will be monitored via court order by the U.S. Probation and Pretrial Services Office. Pretrial Services officers help ensure that defendants released to the community before trial commit no crime while awaiting trial and return to court as required. Pretrial supervision may involve adherence to specific conditions while residing in the community, such as substance abuse programming, mental health treatment, etc. The defendant remains in the community under supervision until otherwise ordered by the court. While under pretrial supervision prior to trial, criminal defendants may be able to carry out their right to vote as he or she has not been convicted of a crime. Criminal defendants should check with their local voter registration office. Adjudication. While under pretrial supervision, criminal defendants will return to court and appear before a federal judge for the purpose of entering a plea to the charges filed. In federal court, the most common pleas entered are guilty or not guilty. In most instances, a guilty plea will coincide with the filing of a plea agreement by the prosecutor, which has been accepted by the defendant and defense attorney. Upon acceptance of the plea and plea agreement, the federal judge finds the defendant guilty and adjudicates him or her guilty. This legal act constitutes a conviction. Where a plea agreement has not been accepted, the case is then set for trial. One other legal issue remains. Defense counsel may request the defendant remain under pretrial supervision at least until sentencing. However, the prosecutor may request revocation of bail and seek detention. To assist with this detention decision, the Pretrial Services officer typically has provided the federal judge with a release status report, which informs the court of the progress of the defendant while he or she has been under pretrial supervision. The federal judge can either detain the defendant or continue pretrial supervision until sentencing. Sentencing. Pretrial supervision may terminate at the point of sentencing, where the defendant may be sentenced to a term of imprisonment or community supervision such as probation. If sentenced to a term of imprisonment and offered the opportunity to self-surrender, pretrial supervision will terminate at the time of self-surrender.